Let me introduce our last speaker of this session, Professor Davor VIDAS from the Fridtjof Nansen Institute of Norway. He has been involved in the law of sea for 30-something, or 40 years, since mid-1980s. And he is a leading expert in the Antarctic and sea level rise related issues. He has published so many articles and books relating to those issues. One of them is a book titled International Law and Sea Level Rise, which all of us participating in this conference may be very interested in. I'd like to kindly ask Professor Vidas to make a presentation.
Thank you very much, Professor Lee, for this kind introduction. Dear ladies and gentlemen, dear colleagues, it is a great pleasure for me to be able to share a few words with you. And I am very grateful to the organizers of this conference for inviting me to do so. I will only share words. I will not share my screen. I do not have a PowerPoint presentation, but I do have some thoughts, some observations, and 19 minutes. Observations relate to what has been ongoing more recently in state practice concerning the options for the maintenance of existing maritime entitlements in face of sea level rise. We are seeing an emerging and in fact already consolidating practice of an increasing number of states in this respect. But let me come to that matter a little later, after some general remarks about the context. And that context has several layers. First, the context of law. The law is, when distilled to its essence, about introducing certainty, legal certainty. That is what law, including international law, should ideally be about. In the sphere of international relations, which is prone, as we know, to political change, international law and the law of the sea as its important part is about facilitating legal stability. In this case, it concerns states' rights in and to maritime areas. Clarity of legal rules is among very important elements here. But sometimes the rules, for which we perhaps initially thought to be quite clear, may prove to not provide sufficient clarity after all. This can happen when new facts emerge, facts which were not known from before. In our law so far, as is reflected in the 1982 United Nations Convention on the Law of the Sea, and we often wish to call it Constitution for the Oceans, facts have been understood as they were witnessed for centuries or even for millennia. Natural conditions surrounding us, in this case, coasts and coastal features, are here taken as a part of a generally stable picture. I emphasize a generally stable, since in all that time, there were certain exceptions, of course. The river deltas, for instance, erosion, or sometimes occurrence of a new volcanic island suddenly appearing somewhere in the ocean. But save for such exceptions or natural changes, as we have known them so far, the law of the sea has relied on a general stability of geography. Changes have been mostly small and slow. For those reasons, reliance on coastal geography as an objective natural feature that is mostly predictable is the cornerstone in today's architecture of the law of the sea building. On this basis, a complex legal structure of maritime zones and their limits and boundaries has emerged. This took, as we all know, a very long time, several centuries, in fact, and is today reflected in UNCLOS, in the Law of the Sea Convention. But the purpose of UNCLOS has never been in geographic stability as such. This is only its helping hand in achieving what is the ultimate purpose, and that is legal stability, legal certainty. The objective of UNCLOS is to facilitate orderly relations between states and ultimately the avoidance of conflicts. We should never lose from sight that one of principal motivations of UNCLOS, as stated in its preamble, is to contribute to the maintenance of peace and security. Now, the other layer of context, that is the changing factual situation. In the interest of brevity, as we don't have much time, let me just quote from an email message which I received some time ago from a Norwegian journalist. He wrote, and I quote here, "I have never thought about the legal aspects of sea level rise before. Do you think that sovereign states will lose their territorial waters under current law? Will EEZs shift with rising sea levels? For instance, if the north of Denmark disappears, will the Norwegian zone increase in Skagerrak?" Unquote. In fact, those questions, except perhaps for this last Denmark-Norway part, are in the essence of what international law scholarship has been debating for quite some time already. And in more recent years, we have seen a growing concern of many states too. At this point, one may ask, what is the size of the factual context? From the perspective of Earth's geological past, a few meters of sea level rise would really not make any headline news. The Earth is in a constant change. It has always changed. But the news for us is that in recent times, the change has become far more rapid, and it looks as it may prove to be more profound in our own time than it was in our earlier history, at least in the written part of it. This is where we stand now, 2 decades into the 21st century. The coming decades may, according to the IPCC and many other scientists, bring major changes, profound changes. It is the context as big as changes of epochs in the history of the Earth. The epoch on which we base our experience began approximately 11,700 years ago, and has, especially in its later stage, in the last several millennia of stable seas, enabled the development of human civilization as we know it today. What we now increasingly witness is a different trend. It is an acceleration of sea level rise as not experienced in the past 6,000 to 7,000 years. So this is the context or the magnitude of challenge that UNCLOS has to face and to persist for as long as it may be possible in order to be able to facilitate its underlying objectives, that is, legal certainty and stability. Now, let us look at the other aspect which I introduced at the beginning of this talk. That is the emergence of state practice concerning the preservation of maritime entitlements in the context of climate change-related sea level rise. At first, we have been able to follow a gradual emergence of views of some states over the past 10 years or so, especially in the South Pacific region. And that is, of course, understandable, since there are many small island and low-lying states over there. Over time, however, those states have been joined by others from several other maritime regions, such as the Indian Ocean, the Caribbean, and elsewhere. So the scope has widened significantly so far in this respect. Also, their views have not immediately taken a clear shape, and it was not entirely clear from the outset whether the trend has been oriented towards developing a new customary law in response to sea level rise, or to rather interpret the existing law as reflected in UNCLOS. But as of this year, those initial unclarities seem no longer present. Two groups of states, which can be seen as those to be specially affected by sea level rise, have, through their regional forums, adopted political declarations aimed at legal interpretation of UNCLOS. It is the Pacific Island Forum, which has 18 members, 14 of which are UN member states, but 16 of which are parties to UNCLOS. And the Alliance of Small Island States, AOSIS, with a membership of 39 states from several regions. There is quite some overlap with Pacific Island members, but so they include also, for instance, Australia and New Zealand, but also included are several African states in the Atlantic Ocean, Caribbean region states, also several from the Indian Ocean and elsewhere, such as Singapore, for instance. On 6th August this year, the Pacific Island Forum leaders adopted the Declaration on Preserving Maritime Zones in the face of climate change-related sea level rise. This declaration can be regarded as their most important and comprehensive collective statement in this respect so far. And its operative part has been almost verbatim reflected in a declaration adopted on 22nd September this year by the heads of states of the Alliance of Small Island States. The implication of the two declarations is that upon their adoption, there are at least 41 parties to UNCLOS now expressly supporting the same interpretation of the Convention regarding the limits of maritime zones and the rights and entitlements that shall continue to flow from these zones without any change, notwithstanding geographical changes of coastline due to climate change-related sea level rise. The key element of the Declaration of Pacific Island Forum leaders therefore deserve some of our attention here, so let me briefly outline it before concluding my talk. The fundament on which the declaration is based is an explicit affirmation that UNCLOS sets out the legal framework within which all activities in the oceans and seas must be carried out, and that the Convention was adopted as an integral package containing a delicate balance of rights and obligations, thus establishing an enduring legal order for the seas and oceans. Building on this affirmation, the declaration is premised on three key aspects concerning climate change-related sea level rise context for UNCLOS. First, the declaration states that the relationship between climate change-related sea level rise and maritime zones was not contemplated by the drafters of the Convention at the time of its negotiation, and that the Convention was premised on the basis that in the determination of maritime zones, coastlines and maritime features were generally considered to be stable. Second, the declaration underlines that coastal states, and in particular small island and low-lying developing ones, have planned their development in reliance on the rights to their maritime zones as guaranteed in the Convention. And third, the declaration recognizes the principles of legal stability, security, certainty, and predictability that underpin the Law of the Sea Convention and the relevance of these principles to the interpretation and application of the Convention in the context of climate change-related sea level rise. Based on those underlying premises, the operative part of the declaration contains two, I would say, key proclamations. Those proclamations specify how PIF members, those Pacific Island Forum members, but also the members of the Alliance of the Small Island States, given their declaration of September, interpret the Convention. The first element in that interpretation is the affirmation that, and I quote, the Convention imposes no affirmative obligation to keep baselines and outer limits of maritime zones under review, nor to operate charts or lists of geographical coordinates once deposited with the Secretary General of the United Nations, unquote. The second element, in consequence of the first, is that, and I quote, maritime zones, as established and notified to the UN Secretary General in accordance with the Convention, and the rights and entitlements that flow from them shall continue to apply without reduction, notwithstanding any physical change connected to climate change-related sea level rise, unquote. Now, most recently, at the end of October and early November this year, so a month ago, a debate was held in the 6th Committee of the UN General Assembly. Many states took part, many of them that are beyond the membership of Pacific Island Forum and Alliance of Small Island States. And that recent debate illustrated several aspects. One is that there is an increasing support to the views of small island and low-lying states, as these are now clearly presented. This is so across several regions, including some EU states, African, Asian, South American, and so on. And of course, there are various reasons for this, spanning from the unprecedented challenges posed by sea level rise to the particular vulnerability of small island and low-lying states, and to the general agreement about the integrity of UNCLOS. And the other aspect to note is that there were no direct protests so far to the practice as described and recently implemented by those states, even though some states have different legislation or practice concerning so-called ambulatory baselines. Yet, as for instance clearly stated by Romania in the 6th Committee a month ago, this practice was not directly meant for the sea level rise context. One major EU country stated its readiness to work towards preserving, and I quote, maritime zones and the rights and entitlements that flow from them in a manner consistent with the Convention, including through a contemporary reading and interpretation of its intent and purposes, rather than through the development of new customary law, unquote. I think that this statement, in fact, summarizes the general slant of views by many other states. With treaty interpretation and subsequent practice or subsequent agreement of state parties as a mean to achieve it, as we know, the devil often lies in detail. However, it is the context and the object and purpose of a treaty, which ultimately must provide the guidance in treaty interpretation. And with this, I would wish to thank you very much for your kind attention.
Thank you very much, Professor Vidas. Your presentation reminded me of the statement made by the AOCs during the UNFCCC negotiations. They insist on 1.5 degrees Celsius target instead of 2 degrees Celsius target. They argued that they could not sign on the documents which included 2.5 degrees Celsius target. They said even though the 2.0 degrees Celsius target could be achieved, the AOC's people would be put into death because of sea level rise. Yeah. Your presentation reminded me that statement. Thank you very much.